what is judicial precedent? Let's start with the big idea. Judicial precedent means judges must follow earlier decisions made in similar cases, especially if those decisions came from higher courts. So this system keeps the law consistent, fair, and predictable. It means people can rely on the law, lawyers can give clear advice, and similar cases are all treated in the same way. It's sometimes called case law or judge-made law because it develops through judges' decisions rather than acts of Parliament. Each major case adds another brick, if you like, to the wall of the law and helps fill in the gaps that Parliament hasn't quite covered. Think of it a bit like judges leaving footprints in the sand. Each one shows the path that future judges should follow. Now, precedent only works because of our court hierarchy, and this is the system that tells us who listens to whom. So here's the order from top to bottom. We've got, firstly, the Supreme Court. Now, they are the top court in the UK. Its decisions are final and must be followed by everyone else. It can even change its own past rulings if needed. Next, we have the Court of Appeal, civil and criminal divisions. Now, the Court of Appeal binds lower courts and usually follows itself, except in a few situations, and it handles appeals on big legal questions. Then we have the High Court, which deals with serious cases and appeals from lower courts, usually follows its own decisions and binds the courts below. And finally, at the lowest level, you have the Crown, County and Magistrates' Courts. They must follow all courts above them, and they can't make any binding precedents. So if the Supreme Court makes a ruling, that same legal principle must be used by every court beneath it. And this structure is essential because it keeps the law orderly, it keeps it consistent, and everyone knows who sets the rules above them as well. Of course, to follow these past decisions, judges are going to need to know exactly what the earlier court has said, and that's why we have law reports. These are official written records of judgments, and they include the case facts, the issues, and the judge's reasoning. Nowadays, judges and lawyers are using online databases like Westlaw or LexisNexis to search for relevant cases. And without these reports, the whole precedent system would just basically fall apart because you can't, after all, follow a case if you can't find it or if you can't understand it. Binding parts of a judgment. Now, when a judge gives their decision, not every sentence becomes law, only part of it. And this is called the ratio decidendi, and that's the part that forms the binding rule. The rest is called the obiter dicta, and that is just extra comments that the judge made that might guide future cases, but they aren't mandatory to follow. So, just in summary then, the ratio decidendi is the legal reason for the decision, and this is the part of that ruling that is binding and must be followed. The rest, the other comments, the extra comments and so on, and examples given, are called the obiter dicta, and they are not binding, they might just be persuasive. A good example is the example of Donoghue versus Stevenson, the famous snail in the bottle case, where poor Mrs. Donoghue drank ginger beer and found a decomposed little snail inside. She sued the manufacturer even though she hadn't brought the drink herself. The court said the manufacturer owed her a duty of care, that you must take reasonable care to avoid harming people who could be affected by your actions. Moving on to flexibility versus certainty. And one of the great things about judicial precedent is that it gives some certainty. Everyone knows where they stand. But the law also needs to be flexible because, after all, times change, and they change pretty fast, don't they? Old cases might not fit with our modern values. So judges have a few clever tools to help them adapt the law when they need to. The first is distinguishing. So this is when the facts are different in two different cases, so the old rule doesn't apply. I've got a good example here. A married couple, Balfour versus Balfour, and a husband here had made a promise to his wife about money, but it wasn't considered a contract because it was just a friendly domestic agreement made, in fact, when they were not separated. But then another case came along, Merritt versus Merritt. And in this case, the couple were separated and they'd had this contract written down. It was a contract. So it was the same topic about money owed by the husband. However, there were different facts. In one case, they were together. In one, they were separated. In one, it was written down. In the other, it wasn't. And so different facts, different outcome. Another way that judges can use a bit of flexibility is when it comes to overruling. So a higher court says a past decision was wrong and then replaces it with a new rule. So an example there is R versus Shivpuri, which was the chap who tried to smuggle drugs into the country. However, it turned out it was just dried vegetables. But that case overruled a previous case, just from the year before, in fact, the Anderton versus Ryan case. And the court admitted actually in that previous case that it had made a mistake. It was only happened a year before, in fact. And then finally, we've got reversing. And this is simply when a higher court changes the decision in the same case on appeal. So consider, why might it be important for judges to have these powers? What if the old law is unfair? Let's move on to look at the practice statement. So before 1966, the House of Lords had to follow all its previous decisions, even if it was clearly wrong. And that made the law very rigid. Judges couldn't fix bad precedents, even when everyone knew they were outdated. And then along came the practice statement from 1966. And this said the House of Lords, which we now call the Supreme Court, could change its own earlier decisions when it appears right to do so. It gave top judges the freedom to correct past mistakes and update the law. But they were actually told just to use it carefully in order to preserve stability within the law. For a few examples here. The first example is Harrington versus British Railways Board, 1972. A case where a 6-year-old boy wandered through a broken fence onto a railway line and was seriously injured. An older case, Addy versus Drumbrack from 1929, had said that landowners didn't owe any duty of care to trespassers, even if they were children. But in Harrington, the House of Lords said that rule was too harsh, and they created a new principle, the common duty of humanity, which says that landowners must take reasonable care if they know people, especially children, are at risk. It showed the courts could make the law fairer and more humane. Another example is R versus Shivpuri, which we've already mentioned. So Mr. Shivpuri thought he was smuggling drugs, but the substance turned out to be harmless. Just a year before, in Anderton versus Ryan, the court had said you couldn't be guilty of attempting the impossible. And the House of Lords realised that was wrong. Of course you can still be guilty if you believe you're committing a crime and take real steps towards it. This case showed the court could admit mistakes and fix them quickly using the practice statement. And we've got one more example, R versus Joji in 2016. Joji was convicted of murder under what's called joint enterprise, which is the idea that if you were present and foresaw a crime, you could be equally guilty. But the Supreme Court decided that rule had been misunderstood for decades. They said to be guilty, you must intend to help or encourage the crime, not just predict it. And it basically corrected 30 years of error and made the law much fairer. The Court of Appeal usually has to follow its own past decisions, but Young versus Bristol Aeroplane created 3 exceptions to this. First of all, conflicting decisions. If 2 older Court of Appeal cases disagree, well, the judges can pick the one that makes the most sense. Secondly, higher court overrules. If the Supreme Court has made a newer decision, well, the Court of Appeal must follow that instead. And finally, per incuriam. If the earlier case was made through carelessness, for example, it missed an important law, well, the law can ignore it. So in short, these rules stop the law from getting trapped by old mistakes. The Privy Council, now that's a top appeal court for many Commonwealth countries and British territories. It doesn't handle cases from England or Wales anymore, so its decisions aren't binding here, but they're often quite persuasive. And judges in England can choose to follow its reasoning if it's clear and helpful. A good example is the Wagon Mound No. 1 case from 1961, in which a ship had leaked oil into Sydney Harbour, and some sparks from then caused a fire and it damaged nearby property. And the Privy Council said that a person is only liable for damage that's reasonably foreseeable, not for every possible outcome. And this idea shaped English negligence law and narrowed who can be held responsible in tort. Let's come to the big question now. This is a big debate, isn't it? Should judges make the law in the first place, or should they just be applying it? Well, against would be the idea, well, look, judges aren't elected, are they? So some people say it's pretty undemocratic. Making law should just be the job of Parliament. But then, on the other hand, judges often have to fill gaps where Parliament hasn't acted, or when new social situations or issues arrive. So we've got some examples here. You've got the Donoghue versus Stevenson, the snail in the bottle case, and that created modern law of negligence. Another example is Gillick versus West Norfolk, a case which decided that mature minors can consent to some medical treatment without their parents. And finally, R versus R, which confirmed that marital rape is a crime. So what do you think? Should judges ever be allowed to create new law? Let's take a look at some advantages and disadvantages of precedent. So first of all, advantages. Well, it keeps the law consistent and predictable. It promotes fairness. Similar cases are treated the same. It also saves some time. Judges can build on past reasoning after all. And it evolves quite gradually. The law evolves gradually and logically, and it encourages clear reasoning by judges. We have some disadvantages too, though, of course. Judicial precedent can be a little bit rigid, and it can be quite slow to change. It can also sometimes lead to unfair outcomes if old law doesn't fit in with modern values. It can also be pretty complex, can't it? Thousands of cases for judges to search through. It can also depend on accurate law reporting too, and it can be pretty confusing when multiple precedents exist. So is it worth keeping this system, even though it isn't perfect? Today, the Supreme Court still binds every other court, but it also keeps the flexibility of that 1966 practice statement. It can change its own previous rulings when justice demands it. Take you back to the case example of R versus Joji. The court admitted it had taken a wrong turn in joint enterprise law and it corrected it. So judicial precedent gives the law both structure and growth. It's a bit like a tree with strong roots, but room to keep branching out. So judicial precedent is all about balance. It keeps the law consistent, but gives judges the tools to fix mistakes, to adapt to modern life, and every major case adds a new footprint in the path of law, and it's those steps that keep justice moving forward. And this shows that the system can change, but that must be done very carefully.